Right.
Yes.
Distinguished professor, respected students, esteemed scholars, distinguished practitioners, ladies and gentlemen, good afternoon. It is my great pleasure to warmly welcome you to the second day of EU-Indo-Pacific Monnet model, that is a 40 hours program dedicated to explore the evolving relationship of European Union with the Indo-Pacific regions. This program is a collaborative effort of prestigious institutions, UC Leuven, St. Louis in Belgium, and the Department of Studies in Law, University of Mysore. This program reflects a strong commitment of academic excellence and establish an international cooperation which providing a platform across border. This program is not only a window to see the European legal mechanism, but it will be a lens through which we can analyze the future of the multilateral engagement. Particularly, today's topic would be covered about European engagement with India, and similarly, Indian and EU trade relationship. And the second hour would be followed by EU and digital strategy by Professor Sebastian. First, we start with the Professor Nicolas. The floor is yours. We shall begin.
Yes, thank you very much indeed. So I shall place the focus on negotiations on the free trade agreements and an investment protection agreements between India and the EU. And so I'll give a few comparative elements. So there's been cooperation between the EU bloc and India since 1994. Meanwhile, India has been concluding trade agreements with different trade partners, be it regional partners or bilateral partners. So countries with which trade agreements have been concluded with Korea, Japan, Singapore, the United Arab Emirates, as well as Australia. So India and the EU, although there are no trade treaties, are already important trading partners. Trade in services as well as in goods is increasing sharply. When it comes to goods, India has been, the EU has been for India the largest trading partner, and India was in 2023 the 9th largest trading partner in the EU. So as a matter of course, these figures do change year by year, but the figures highlight the importance of EU imports in India, as well as Indian imports in the EU that do increase year by year. Trade in services is becoming quite significant, and that's for the reasons that today's lectures will be focusing on the digital economy that could actually boost trade in services between the EU and India. So these figures show you the importance of trade in services with India, in particular regarding transport, travel, intellectual property, ICT, and so on. So, of course, this is lectures on law. The European Commission is taking the view that today EU businesses are facing technical barriers to trade and also sanitary and phytosanitary barriers that deviate in India from internationally agreed standards. So of course, this is the statement of the Commission. I don't know on what this statement is reckoning. And they claim that there has been discriminations based on legislative or administrative measures that do affect an array of sectors encompassing goods, service, public procurement, and investments. So given this background, the EU is attempting to conclude different economic treaties with India in order to eliminate these obstacles. And for that reason, in 2022, negotiations were launched with the aim to concluding, on the one hand, a free trade agreement, on the other hand, an investment protection agreement, and a specific agreement on geographical indication, which is a topic of high importance for European businesses. A few months ago, at the end of February, the president of the European Commission, so she's not the president of the EU, but she's president of the executive, von der Leyen, met Indian Prime Minister Modi, and they jointly agreed that both sides could conclude negotiations in the course of 2025. So there are no further specifications regarding the speed at which these agreements could be concluded. There are, from as far as I'm concerned, still a number of stumbling blocks. So this is just an extract of the von der Leyen's and Modi statements at the end of the month of February. They stressed that the EU and India are the largest democracies, so that was discussed yesterday in the course of our lectures. They are endorsing an open market economies, and their societies are indeed pluralistic. So the parties are committed to buttress the economic growth and sustainable development in this complex multipolar global order. Of interest, we discussed yesterday the values upon which the EU is based, be it dignity, freedom, fundamental rights, the rule of law, and democracy. So these values are listed here. The principles of the United Nations Charter. So I forgot to mention that Article 21, paragraph 2 of the Treaty of the European Union states that the EU is bound by the principle of the United Nations Charter. And so all these shared values make the EU and India like-minded partners. So that's pretty much the terms used by the European Commission's like-minded partner, although there are key differences between India and the EU, as you are aware. Of interest is that in the fifth paragraph, they stress the importance of intensifying cooperation in different trades that we shall discuss today and tomorrow, be it trade, be it the control of supply chains, investment, digital and green industrial transition. So Sébastien Faso shall deal with the digital transition, and as well as governance of artificial intelligence. We already mentioned the Artificial Intelligence Act of the EU, and I shall discuss the climate change objectives tomorrow. So roughly speaking, the objectives of these negotiations that should lead to the conclusions of 3 different treaties is, on the one hand, to remove obstacles, barriers that were denounced by the European Commission, to open up services, because tomorrow's economies will be much more a service economy than trading in goods economy. Public procurement markets, to open the public procurement markets in India to European business, and to ensure protection of geographical indications, be it for the feta in Greece or the French wine or the French camembert, so which is of importance for European business. But what matters is also the issue of sustainable development that I will touch upon quickly now, and that I will discuss time and again tomorrow. So to make the link with the introductory lectures, these agreements are falling within the scope of the common commercial policy. So that's very clear. Be it their aims, be it their structure, be it their nature, be it their obligations, everything unfolds around trade. Although there are chapters on labor protection, on environmental protections, on sustainable development, and so on and so forth. But the hardcore of the three agreements is trade. And Article 207 is extremely clear on the matter. It encompasses the common commercial policy, encompasses the IPRs, encompasses investment issues, encompass also trade in goods and services. And as I explained time and again, this common commercial policy is fleshed out in the conclusions of specific agreement. And so what matters here is the manner in which the different EU institutions will be or are involved in the negotiations for the conclusions of these three treaties. So as I stressed, the central actor regarding the negotiations is the European Commission. So the European Commission obtained a mandate from the Council of Ministers, so the configurations gathering the minister for not foreign affairs, but for the external trade, gave the mandate to the commissions, and the Council of Ministers does oversee the negotiations undertaken by the commissions and the Indian authorities. And of course, these negotiations require a number of rounds. So it's negotiators are moving from one round to another round in order to achieve specific results regarding the 30 chapters. So the aim of the negotiation is to conclude the three trade agreements, but the Council of Ministers is called on to conclude. So the Council of Ministers will have the last word, provided that the European Parliament grants its consent. So the Parliament is not involved in the negotiations, although the Parliament is following what's going on. But the European Parliament has always at disposal the atomic bomb. So in case the Parliament is not satisfied with the result of the negotiation, it has the veto's right to oppose, and so the draft agreements will go nowhere. So this is a timeline. So we are actually at the level of the negotiations that should perhaps lead to the signature of the, so that will be the very first formal step of one or two or three of these agreements. So it means that the content of the agreements won't be subject to further negotiations. And then the second formal step will be the consent granted by the European Parliament. So it will be a majority of the MPs supporting the agreement. And thanks to this consent, the Council of Ministers, configurations, so of the ministers in charge of external trade, will ratify or will conclude. So the conclusions requires the adoption of a specific decision that will be published in the official journal of the EU in the 24 languages, official languages. So as I stressed, and that's really of importance for the participant, is this is an exclusive competence. So the common commercial policy falls within the scope of exclusive competence, and it entails that there is no member states intervention. So the national parliaments are not called on to ratify or to conclude the agreement. So it's a situation that's very different from an agreement on the law of the sea or an agreement on on climate change, the Paris Agreement. So these agreements, because they deal with mixed competences, they will require the ratifications by the Council on the one hand and by the 27 national parliaments. So here we are in a scheme that's much more specific. When I mentioned the third paragraph of Article 207, and the Commission is actually, according to this paragraph, conducting the negotiations in consultations with the Special Committee for Trade. So there is a special committee gathering the German, French, Luxembourg, Dutch, Belgian civil servants. And so the Commission must report after each round of negotiation to this committee. And so when the negotiations will be terminated, the agreement will be signed and it will be concluded. And again, that's in sharp contrast with the association agreements under Article 217. The ministers can conclude the agreement according to a qualified majority. So you remember the two standards, 55% of the countries representing 65% of the European populations. So it's really of importance is that the Indians understand quite well the procedure in the EU. So in a nutshell, exclusions of the national parliament. However, the possibility that the European parliaments might veto the one or two or three of the agreements, and then this constant interaction between the European Commissions that negotiates the agreements and the special committee of the Council, so to enhance a smooth approach. What's really very tricky, there will be a specific investment protection agreement. So you might beg me the questions, why on earth a two-pronged approach? Why was it not possible, such as under the CETA treaties? CETA treaty is the Canada and EU treaty, to include an investment chapter into the main trade agreement. That's done for issues related to competences and ISDS. So the investment protection chapters, unlike the trade agreements, will require the intervention of the 27 member states. So I need to explain that on my slides. And so that's in accordance with an opinion delivered by the Court of Justice of the European Union. Provide that this investment protection agreements entails an ISDS scheme, so a scheme, an arbitral scheme. But so I imagine that the ongoing negotiations regarding investment protection will unfold again around the traditional provisions, non-discrimination, protections against expropriation without compensation. So expropriation is possible, but provide there is a fair compensation, and protection against unfair treatment of investors and investments, while preserving the right to regulate and the transfer of return. So I imagine that it will be a fairly classical invest protection agreement, somewhat similar to the investment protection agreement concluded 4 years ago with Singapore. What matters to the European Parliament and to several member states, such as the Kingdom of Belgium, is the sustainability issues. So there is much controversies in my country regarding the sustainability as well as human rights. And the European Commission is called on as a negotiator to conduct a trade and sustainability impact assessment of the impact of the forthcoming agreement on societies, the environment, economy, but also enjoyment of fundamental rights. So far, this impact assessment has not been published, and I have no idea when it will be published. But this is a commitment. It's not provided under treaty law, but it's a policy commitment of the European Commission to publish an impact assessment of any trade agreement. So there are progresses in different areas. Apparently, this progress are uneven. So far the chapters that I conclude are not yet accessible, but the progress relate to the public procurement, SMEs, competitions, customs and trade facilitation, and even sanitary and phytosanitary measures, which is a point of contention. The European Parliament that will give consent to this agreement handed down a resolution in 2022. And so there is no new resolution, oddly enough, and the Parliament stressed the need to prioritize sustainable growth, digital and green just transition. So that will be the subject that we shall deal with, the topics, the subject matter we shall deal with in the coming hours, to assess whether the international labor organizations' principles, core principles or core agreements are correctly applied, and to ensure that the forthcoming agreements are in line with the European Green Deals, the Farm to Fork strategy, and also the climate change policy commitments made under the UNFCCC conference of parties. So I shall deal with all these topics tomorrow. And so there's also a mention of a specific court. So will be a specific EU-India investment court that will be provided for under the investment agreement. And this court should be part later on to a multilateral investment court. So that's a project of the European Union, is to get rid of the traditional ISDS model that's quite too favorable to investors, and to accept an investment court that's more similar to a traditional court. Of course, there are obstacles, and it seems to me that one of the main obstacles is agriculture. Agriculture is also an obstacle in the negotiations with the Mercosur countries because, as I explained yesterday, cattle production is much cheaper in Paraguay or in Brazil than in Europe. And so the farmers in my country or in France are really afraid to be seriously impacted by cheaper imports of meat. And so here apparently the India has been raising very high tariffs on agricultural products and dairy products imported from the EU, 39%, whereas the tariffs on the EU side are much lower. So it entails that India will have to cut its tariff much more than the EU. Of course, the Indian point of view is that these duties are necessary in order to protect domestic productions and to support the livelihoods of millions of farmers, small-scale farmers and milk producers. And as you're aware, the Indian agriculture is characterized by extremely small-scale farming activities, whereas agriculture is much more intensified in the EU. So that's perhaps one of the key points of contentions. Another issue will be the chapters on sustainable development. So the idea behind these chapters is that Europe is achieving fairly high standards when it comes to environmental protection, consumer protection, sustainable development, and also labor protection. So it means that it's much more expensive to produce goods and services in the EU than in Canada or in United States. The labor force is more costly, energy is more costly, but in addition, a business has to cope, have to apply, have to abide by a number of quite stringent regulations aiming at protecting the climate, the environment, the consumers. And so that increase the price of European goods and European services. And so the ideas of the chapter is to enhance a level playing field at a global level, at least with the economic partners of the EU. So in other words, is to promote higher standards with a view to avoiding that European business are penalized in the context of the application of a trade agreement. So I just give you a few examples here. When it comes to labor, so labor, it's extremely touchy issues, as you're aware, because the wages of an Indian labor in a steel mill, it's much lower than the wage of a French laborer. And so here, the chapter, or at least the chapters I've seen in other agreements, provide for a non-regression clause. So the applications, the implementation of the agreements should not lead to undermine the level of protection that already exists. Secondly, the parties to the agreement should abide by the existing industrial commitments, which are the ones from the Industrial Labor Organizations Convention. So it means that the domestic Indian legislation should be consistent with the obligations provided for under the ILO conventions, and there are also a few aspirational clauses. So just to give an idea of the minimal level of labor protections, the freedom of associations of collective bargaining. So association means to be member of a trade union, the eliminations of all forms of forced or compulsory labors, the effective abolitions of child labor, and eliminations of discrimination. So that's a few. And so each objective relates to a specific convention. So there's also the issue of non-regression clause, such as the domestic legislation should not be modified in order to make the economic partner more competitive. And then there are a number of aspirational clauses to make an endeavor to achieve a higher level of protection when it comes to environmental issues or to labor protection. So of course, for lawyers, aspirational clauses are of hardly no interest. Of course, for lawyers, what matters is the dispute settlement. Here it's somewhat tricky because it's very diplomatic. It's fairly different from the traditional dispute settlement before the World Trade Organizations. Firstly, there are government consultations, and then there is a special dispute settlement mechanism, a panel of experts, and this panel of experts is issuing recommendations. So they hardly do that. There are a few litigations. So there's been a litigation between the EU and South Korea regarding the implementation of the labor provisions of the trade agreements concluded between the EU and South Korea. And so the EU complained that South Korea was not concluding or implementing some of the international labor organizations treaties, and the dispute went to this panel of experts, and they just issued a rather light recommendation. So the labor protections federations or trade unions in Europe were quite dissatisfied by this dispute settlement process. To conclude with, the conclusion, at least of fair trade agreement between India and EU will have an impact upon the tariffs. Tariffs on the Indian side as well as on the EU side, so that should boost the trade in goods between the two countries. So given the tariff wars with the American administrations, of course, there is a room of opportunity in concluding such trade. The question is whether the Indian authorities or the EU authorities are ready to accept significant diminutions of tariffs that will make Indian goods more competitive on the EU market, or vice versa, so European goods more competitive on the Indian markets. So there are so many chapters, it's difficult to conclude whether the process will be successful, but just as a reminder, the EU succeeded to conclude lately agreements with New Zealand, Vietnam, Singapore, South Korea, and a few years ago with Mexico and Ecuador and Colombia. Given the international context, there might be pressure upon the negotiations to reach a proper agreement. And so that will somewhat bring the two continents much closer. So it's voilà, but at least in looking between the lines, it's clear that climate change and environmental issues, as well as labor protections and the digital economy are at the core of the negotiation. Thank you very much indeed.
So now we're looking for some questions. Some students have put questions they have raised.
Yes, please.
Yes, you can. Now you can ask your questions.
I hear nothing.
I think there's no questions now.
There's no question?
No.
Okay. Okay, but then I propose that we continue right away with Sébastien.
Yes.
Okay, then I will continue and continue with the digital strategy of the European Union.
Yes.
I will share my slides. Wait. Okay, I guess you can see them now.
Very able to see it.
Perfect. So there's actually a lot to cover, and indeed, Professor de Sadeleer already introduced some of the topics that we will discuss today. But what I will try to do today is give you a very broad perspective on the EU's digital strategy in general, and try to relate it as much as possible with the Indo-Pacific region and why it matters for the Indo-Pacific region, and how it can impact the relations between the EU and countries from that region. We have a lot to cover, and between today and tomorrow, as you would have seen in the program, and I'm not sure we will actually have time to cover everything, but this is the outline that I prepared. And at least now we will, the first part is quite important, I think, and it relates to the global reach of EU digital regulations. I think it's great in this module to start with this topic through the study of the General Data Protection Regulation that that I already introduced yesterday, and which precisely has had a very important global reach globally. Global reach. So let's start with this. Then, if we have time, I will continue with the EU's digital strategy. Give you a very broad perspective on the EU's digital strategy that has been in the making for the past 10 years, at least, in a more consistent way, and then deal with some specific issues in this strategy. So, for example, focus first on digital infrastructures and how that impacts the Indo-Pacific region, especially with discussions around the European Chips Act that was recently adopted, 2 years ago. Then that will be tomorrow. I will discuss the European data strategy with the Data Governance Act and the Data Act. And then I think what is even more interesting, maybe, because there's really a lot of discussions both on the regulation of online platforms and the regulation of artificial intelligence. I didn't put the number of the AI Act here, but it was adopted last year, and so it's a very those are very topical instruments, and I think it would be interesting to also kind of see how it can impact the relations between the EU and the Indo-Pacific. So let's start now with the global reach of EU digital regulations. And to understand the global reach of EU digital regulations, I think it's very important to first understand the different types of regulatory models that we can find globally in the regulation of digital technologies. No? And to do that, there's been a construction of a theory, or at least an argument made by Anu Bradford, who is a Finnish law professor at Columbia University in New York, and she published a few years ago a book that has been very talked about, called Digital Empires, and in which she differentiates between three main regulatory models for digital technologies in the world, and that she summarizes basically those models based on the one in the US, which is more of a market-driven model, the one in China, which is, she argues, more of a state-controlled regulatory model, and the one that we have in the EU, which is rather a rights-driven model. And we've already introduced that with the institutions yesterday, and the very important role of the Court of Justice of the EU in building that regulatory model. And we will come back on seminal judgments by the court in the past years. Of course, these are models, so it doesn't mean that the EU is only focused on rights. It doesn't mean that the US is only focused on markets. Actually, there's a lot of state intervention also in the US in digital infrastructures, in digital markets. And it doesn't mean that China is only concerned with controlling with state control. No, so we will try to make sense of this. But so if we need to differentiate between the three, the US model, which is more based on which is more of a market driven model, focuses on obviously on free markets and on innovation, on minimal government interference in the economy, at least in the digital sphere. And with this idea, for example, which is very relevant for the regulation of online platform, that free speech is of utmost importance, and so in order to preserve free speech, there should be less state intervention, and they actually have, especially compared to the EU, a very maximalist vision of free speech. No, whereas in the EU there are safeguards to ensure that free speech is balanced with other fundamental rights. There's also this kind of techno-optimist approach in the US with regards to digital technologies, and the fact that technology can, the belief that technology can help with economic prosperity and societal progress. So how does that model spread its power globally? Anu Bradford, she argues that power is spread by the private tech giants that are based in the US, and that's why I think also it's very relevant to discuss the regulation of online platforms, as we will do tomorrow. The Chinese model is more of a state-controlled model, she argues, where the government basically exercises significant control over digital technologies to ensure societal stability. So there's a focus on on surveillance, on censorship, and on the control over data and personal data. We will see some cases related to that. And they have a very proactive industrial policy also, with subsidizing the companies, subsidizing investments in infrastructures in ways that are much greater than in the EU, for instance. And that's why she argues that the Chinese state control model is spreading its power through infrastructures, for example, with telecom infrastructures, so the 5G, 6G networks, and we've seen the conflicts that this generated, for example, between Huawei and in the US, and other issues. Then there is the EU, or the European rights driven model, and basically we will focus today on this model. And what is very important to understand in this model is that there is obviously a double objective, not only the objective of protecting the fundamental rights of individuals and private parties in general, but also to ensure the free movement of services and of data within the internal market. And so there's always this internal market imperative that is present, and I will come back to that. So a very special characteristic of the EU. Why is it a rights-driven model? Because in order to protect these fundamental rights, such as privacy, the EU has adopted, and you will see that today and between today and tomorrow, a lot of different regulations that are quite far-reaching, just like the GDPR that we will comment today, but also the Digital Services Act, the Digital Markets Act, or the AI Act that we will discuss tomorrow. And so that's why she argues that this model is spreading globally through regulation. She's also the author of, and she coined the term the Brussels effect, which I ended the session yesterday on the introduction of EU law with saying that the EU had a very important regulatory capacity and the capacity to influence norms and the adoption of norms that are similar to it outside of the EU. And we will come back to that also. So those are the three models. But as I said previously, she argues that those models are not exclusive from one another. No, in the EU, there are also investments and subsidies for the development of digital infrastructures, and we'll come back to that later with the European Chips Act, for example, which is meant at developing the developing investments in the production of semiconductors in the EU. And similarly in the US, even though at the federal level, for example, there is a kind of a laissez-faire approach to digital technologies, at the state level, you also see the development of regulation, for example, to protect privacy. In California, for example, there's a regulation in place which is actually very similar to the GDPR in the EU. So no model is absolute, and you can find in the end a mix of the three in different countries. No, she addresses also in this book in this book the trade-off between regulation and innovation, no? which was especially discussed about during the adoption of the Artificial Intelligence Act, with a lot of actors in AI explaining that we should definitely not regulate too much artificial intelligence and AI systems and AI models now, because it's in full development, and so regulation would actually hinder innovation, and that would not lead to good outcomes for the economy, for growth, and whatever. So she addresses that issue, and indeed she argues that both are not again exclusive from one another, and that indeed regulation, and that's the view generally in the EU, is that regulation can also foster innovation, and that relates again to the specificities of the EU as a kind of supranational organization comprising 27 member states, where indeed for businesses to flourish in the EU, you need to have some kind of harmonization so that the standards in terms of product safety, for example, are similar, and to enable the flow of products and services within the internal market. No, so in the EU, regulation is seen also as something that can promote innovation. Companies prefer to comply with only one set of regulations, of EU regulations, instead of having to comply with 27 sets of regulations from the different member states. No, so the approach to regulation is much different in the EU, also because of this characteristic, which is what I just explained. Also in the EU, there is obviously no uniform approach all the time. It's 27 member states, and so the member states have very different views on regulation, on innovation, on the protection of fundamental rights. And so we will come back to that related to the GDPR. Actually, I will give you an example. But even between countries like France and Germany, there are sometimes important differences, for example, in how the protection of privacy is thought. I think that was the idea that I wanted to explain now, is kind of before entering into the EU regulation, the EU digital regulations, is kind of give you a global perspective on the different types of models that exist and which are obviously not exclusive from one another. Okay, so now that we've seen that, to what extent is the EU regulatory model actually rights-driven? We will see between today and tomorrow that the EU adopted a lot of regulations, especially in the past 5 years, actually, which are summarized here, and there are so many that you can probably not even see them, and that's made on purpose. So I kind of summarized here what they encompass. We could discuss much more than this, but in order to kind of summarize, I think it's good to kind of differentiate them between those that relate to data and to infrastructures. And today we will discuss the CHIPS Act and the GDPR that were respectively adopted in 2023 and in 2016. But there's also the e-privacy directive that has been in place since the turn of the millennium, the Cybersecurity Act of 2019, and then tomorrow we'll see the Data Governance Act and the Data Act. There's a set also of regulations that are more concerned about specific actors. So obviously today we'll discuss online platforms, which have gained a very important role in society and in the economy. And indeed, very last year also the European Union adopted the platform work directive, which was actually a very similar directive to what was adopted in Spain, and I will come back on this. So regulation of specific actors and regulation of data infrastructures, and then a third set of rules that are more related at regulating specific practices or specific conduct in the digital environment or in the digital economy. So the first set of rules in related to practices are quite obviously competition rules. So Article 102 of the Treaty on the functioning of the EU has been to regulate competition in digital markets, and especially with very important cases against Google, against Meta, against Intel in terms of infrastructures and semiconductors. So we will come back on some of these issues. But there are also important rules in terms of consumer protection, for instance, in terms of the protection of intellectual property rights. Here I mentioned the copyright directive, but we could also discuss trademarks, for instance. And then specific uses of artificial intelligence. We will see that the AI Act that was adopted last year, we'll see that tomorrow, is actually focusing on specific uses of AI systems, case uses. So that's it. The rights model is indeed why is it a rights model? Because there's this focus on the protection of fundamental rights, and we will come back to that, but also the regulation of personal data, online platforms, artificial intelligence, and this set of rules that I just mentioned. Again, to come back on this, the specificities of EU regulation, which I think is very crucial to understand all of them, is this double objective of that they have between harmonization and protection. Everywhere you look at the regulations, EU regulations, and even outside of the digital sphere, you always have this kind of double objective, of harmonizing the legal systems and the rules between the 27 member states. So that's what has been called the single market or the internal market imperative. And in the digital sphere, there is a strategy also, the digital single market strategy, to do the same online as offline in terms of free trade between member states, and the fact that digital services should should be provided without barriers between the member states. In terms of legal basis for the adoption of those regulations, we've seen that Article 114 of the TFEU, the Treaty of the EU, is the fundamental legal basis under which a lot of these regulations have been adopted in the recent years, and it's the legal basis for adopting harmonization measures for the well-functioning of the internal market. But we will see that it's actually not the only legal base that has been used. For example, for the GDPR is, I will come back to that. But there's also this other objective, which is the objective of protection, the protection of fundamental rights. So not only the protection of the free speech, just like in the US, where you see this very prominence of the protection of free speech. It's not only free speech here, it's also the protection of privacy, the protection of human, especially with the GDPR, the protection of human dignity, for example, with the AI Act that we will comment tomorrow, but also the protection of democracy, of fairness, and this is really, you can see that all over EU digital regulations. As a social market economy, the EU is also concerned with the protection of individual and collective rights of a number of stakeholders. So, for example, consumers, obviously, but also workers, as I mentioned, for instance, with the Platform Work Directive, and, for example, publishers with the Copyright Directive. Yeah, as I mentioned, the GDPR, for instance, is a very good example of this double objective. It was adopted on the basis not only of Article 114 of the TFEU, which relates to harmonization measures between member states, so to enable the free flow of personal data between member states. It's also concerned with protecting privacy of individuals when their personal data is being processed not only by private actors, but also by public authorities. And that's why it was adopted also on the basis of Article 16 of the TFEU, showing the importance of the protection of this fundamental right. The GDPR is also a very good example of the compromises between member states in the EU. I mentioned that previously, but for example, France and Germany have quite different approaches to the protection of privacy. For historical reasons and for the abuses on privacy and the privacy of individuals during the Second World War and after that in Eastern Germany with the Stasi, with the authorities and the state that was actually violating the privacy of especially the Jews. In Germany, privacy is really seen as a very important value and a very important fundamental right. Maybe more than in France if you compare, and you see that in legislation, in policies. For example, in France, there has been a history of adoption of laws that are actually more dangerous for privacy than in Germany. For example, during the last year's Olympic Games in Paris, a law was adopted to be able to for example, surveil, avoid terrorist attacks, and to use, for example, facial recognition cameras on the streets and stuff like that. No, so you can clearly see a difference between the two member states, but yet this regulation was adopted, and usually the fact that this the compromise between 27 member states make it so that the EU regulations are characterized by this compromise that can be that can usually serve as a quality seal for these regulations, if you want, because of the compromises that have been reached. Very importantly, also the GDPR is a good example of how, with its small budget, the EU has a relatively small budget. Actually, if you compare it to other, for example, if you compare to the EU to the US, the EU budget has around 1% of. It's only around 1% of the GDP of the EU, of the different member states. In the US, the federal government is around 20%, has a budget of around 20% of the GDP of the country. So it's so the EU bureaucracy is sometimes pictured as a very bureaucratic and very heavy and whatever. But in terms of budget, its resources are actually relatively small, and that's why. And we explained that yesterday. Member states play a very important role in the enforcement of EU regulations and EU law. No? So, for example, for the GDPR, it's the authorities of the member states which enforce the rules under the GDPR. And I've already mentioned, for example, yesterday, a fine of the Irish Data Protection Authority against on TikTok of around 500 million euros. This is the national authority implementing and enforcing the rules adopted at the EU level, and it applies across many different areas, not only data protection. Despite the fact that one of the objectives of the GDPR is to enable the free flow of personal data within the internal market, that doesn't mean that the rules do not have an impact outside of the EU, and indeed, especially the GDPR has had a very important impact globally, and that's what we will discuss later. But first, let me give you an example again of the EU's rights-based model, based on a very important case that was issued in 2014, so before the adoption of the GDPR, to show you also that the GDPR is not really the first set of rules on data protection. Before the GDPR, there was the Data Protection Directive, and since this case that I will explain just now, there's this possibility, and I don't know if you've ever seen that. When you search for people on Google, for example, you see sometimes this notice, at least when you're based in Europe, saying that some results might have been removed under data protection law in Europe. And when you click on learn more, you learn that it's actually Google is implementing a judgment of the Court of Justice of the EU, which I will now explain. The case concerns Google, actually. Google Spain. It's a case in Spain that originated actually in Barcelona, because so La Vanguardia is a very important, one of the most important newspapers in Spain and especially in Catalonia. And a data subject, a citizen called Mario Costeja, he had issues with the tax authorities in Spain because he had not paid his taxes or whatever. He had not paid his taxes, and so he had debts towards the public administration. And so in that case, the public administration can seize the assets of someone that does not pay its taxes. And so back in the years 2000, Mario Costeja had some of his assets sold, and that was advertised in the newspaper La Vanguardia. And so actually his assets actually, I think, were sold, or in the end, he did not have any debt problems with the tax authorities in the end. But still, in this newspaper, especially online, there were online articles related to his tax problems and related to his assets being sold. No? So he was not happy about that years later, because actually all of his taxes had been paid, and still when you typed his name on Google, people could still consult these articles about him in La Vanguardia, and those appeared on Google. And so he complained to the Spanish Data Protection Authority. And the case in the end reached the Court of Justice of the European Union, which in 2014 had to adjudicate the case and issued the judgment. And so the Court of Justice had to make a balance between not only his right to privacy, of this individual. He was arguing that the search engine should not contain articles of his name if the problem that he had suffered with the tax administration had been solved, so because it was not relevant anymore. But the balance had to be with privacy, but also the freedom of expression and information, especially the freedom of information. No, it's true that even though he was a normal citizen, in some cases, for example, in the case of politicians, you would like to know if someone you're about to vote for has not paid his taxes or her taxes before. No, so the freedom of information is important, and then there is the right of Google, which is also a fundamental right to commercially exploit the personal data, the fundamental right to conduct a business, which implies also the commercial exploitation of personal data. So in the balance between the three, the court decided to give a more importance to the right to privacy, and actually, based on the directive, the Data Protection Directive created the right to be forgotten. It's called the right to be forgotten, where individuals can ask a search engine to remove search results about them when those results are not relevant anymore, and under some conditions. So that's a possibility under the law in the EU, and actually the GDPR incorporated that right when it was adopted in 2016, and now there's a right to be forgotten, the right of erasure of your personal data under the GDPR. So that's to illustrate also basically the rights-driven model of the EU, is that the Court of Justice also has a very important role in interpreting those regulations, in this case, privacy regulation, and you can see that they are also establishing new rights based on these regulations. So the court is a very important role, and we will come back on that with other cases. So the GDPR became applicable in May of 2018, and it was presented as a very big change in how the EU was regulating personal data. This is the regulation. And indeed, even though many of its rules and principles were kind of similar to the previous regime under the Data Protection Directive, it was a real change for for different reasons. First, the previous Data Protection Directive was a directive, and so it was not the level of harmonization was less important than under a regulation, which is directly applicable in the 27 member states, whereas under the Data Protection Directive, all the member states had to adopt national laws that would transpose its rules. So first, in terms of harmonization, the framework is much more harmonized now, but also there are new rights. As I said, there is this new right, for example, for the right to be forgotten, but there are other rights also. the right to data portability, for instance, and I will come back on that. And also it regulates, but that was also the case before, but it regulates the data transfers, so the transfer of personal data from the EU outside of the EU. So we will see an important cases related to data transfers from the EU to the US. But I also mentioned that TikTok was just last month fined €500 million for illegally transferring personal data from the EU of EU users to China. So the big change with the GDPR also is the enforcement mechanism compared to the previous regime, because the sanctions that can be imposed on companies and public authorities are actually very important, especially on companies. The companies can be sanctioned up to 4% of their worldwide turnover, annual worldwide turnover. So it can reach very important levels. Those are the rights, the main rights, if you want, under the GDPR. The GDPR, and I will not go too much into the details because we don't have much time for this, but the main idea is that data subjects need to be informed when their data is being processed. So there's a lot of obligations of transparency, but also the obligation to process the personal data lawfully, so according to a specific legal base. There's this focus on consent, that individuals, data subjects should consent to the processing of their personal data. And then also the right to access, for example, to ask organizations, what data do you have on me? The right to rectify this data, the right to object to the processing of specific types of data. So for example, like direct marketing or for profiling techniques. And actually my PhD thesis is focusing a lot on digital marketing. But also the right to data portability, so the right to take your personal data from one provider of a service to another provider, the right to erasure that I just mentioned, and then also the right of related to automated decision making. But what I think is very relevant so that there's this very important and far-reaching set of rights. But for this teaching module, I thought it was interesting to delve a bit more into the rules related to international data transfers under the GDPR. For instance, so what does that mean? Is that the personal data of residents in the EU cannot be freely transferred outside of the EU, except when mutual adequacy decisions are being adopted. And so the European Commission can decide to say that a third state is actually an equivalent or a very similar set of protections than in the EU. And therefore, when the European Commission adopts what we call an adequacy decision, because the third state has an adequate data protection regime, then there is a free flow of personal data between these countries, and so between the EU and these third countries, a bit like a free trade agreement, but for personal data, if you want. No? So in this case, the European Commission has adopted adequacy decisions for the following states that you can see on the slide. So and Andorra, Argentina, Canada, the Faroe Islands, but mostly in the Indo-Pacific, Japan, the Republic of Korea, New Zealand, and then elsewhere you also have and I will discuss that, but the United States, and very important developments on this, or Uruguay. So an important set of countries. India, for example, I note has not been the subject of an adequacy decision by the Commission. Maybe given the discussions around the free trade agreement with India, maybe, and there are voices calling for the Commission to adopt such an adequacy decision. But the European Parliament, and I've seen some parliamentary questions and parliamentary questions on the topic, questioning whether India has an adequate data protection regime for the Commission to adopt such an adequacy decision. But I will come back on that because India, as you know, has also adopted a very similar regime to the GDPR. What is the effect of these rules? Is that in the end, just with these rules on international data transfers, it leads third countries to actually align their privacy frameworks and their privacy regulations with the EU regulations, especially under the GDPR. It contributes to this Brussels effect that I mentioned before. In this case, the de jure Brussels effect, in which third countries are influenced by how on how they adopt privacy frameworks and how they align it with the EU. Very importantly, I thought I had no, it's after this. This has led to some of the highest fines under the GDPR, actually. Infringing the rules on international transfers under the GDPR can lead to very heavy fines. I've already mentioned TikTok last month, but 2 years ago, Meta was also fined more than 1 billion euros, 1.2 billion euros for violating those rules, and I will come back on that now. So it's actually the highest fine under the GDPR. So this Brussels effect, how has the GDPR influenced privacy rules in the world and also in the Indo-Pacific? If you look at the case of Japan, for example, already in 2016, trade organizations and associations and export organizations in Japan were already telling the members and the companies that they should actually comply with the rules of the GDPR, because then it would allow them to trade with the EU in those related to personal data. No? And you could already see that in 2016. In the meantime, in 2019, the Commission adopted an adequacy decision, for example, related to Japan, and it's actually this adequacy decision has created the world's largest area for the free flow and the safe flow of personal data in the world. No, so very important consequences. Same for the Republic of Korea. There's also an adequacy decision with Korea. What does that mean? Is that the safeguards that are established in the EU privacy framework are also very similar in the third countries for which the Commission has adopted adequacy decisions. In this case, Japan, and so you have a set of for example, the ability for EU citizens to complain before the authorities in Japan, and additional safeguards that we don't have time to go too much into details. So that's how basically it shows how in third countries they are keen on adopting similar rules than in the EU to access this market and to create trade opportunities between them. No? That's what we call the de jure Brussels effect, the ability to influence the adoption of norms outside of the EU. Then you also have the case of companies that actually decide to align their practices, their data practices in the case of the GDPR, to the framework and the rules in the EU. In this case, look at the example of Microsoft. Just 4 days before the GDPR became applicable in May 2018, Microsoft announced that it would apply GDPR rules to all of its customers globally without differentiating between the EU, the Americas, the Indo-Pacific, or specific countries. No, so all of its practices would respect the GDPR. That's what we call the de facto Brussels effect. It's the fact, the ability of EU norms to create incentives for companies to adopt to adapt, their practices based on EU regulation globally. So why? I mean, there are many reasons why. Obviously, one of them is that the EU market is difficult to avoid, especially for a company like Microsoft. And so instead of changing and adapting their data practices in different regions, they decide to just adopt the strictest set of rules, which is the EU framework, and adapt and apply it worldwide. No. Also, there's a question of reputation, obviously, a reputational question. If you decide to afford the high protection of privacy and data protection to your customers in the EU, but not, for example, to your customers in India, then in terms of reputation, maybe it can affect the company. Because why afford the different sets of protections in this case for a data firm, no, a big tech firm? Okay, so that's the de jure and the de facto Brussels effect. And let me know when we need to stop, because I lost track of time. But I will continue with international data transfers. Because there's been 2 important cases at the EU level. So 2 important judgments, of the Court of Justice of the EU related to the transfer of personal data between the EU and the US. So even though you have the Commission adopts adequacy decisions for third countries, actually they can be challenged in court. So it's a decision that can be challenged, and that was the case for the adequacy decision with the EU, with the US. Sorry. So you have this Austrian activist, a privacy activist called Max Schrems, very influential in privacy protection in the EU. Which at the time was, I think he was a law student at the time in Austria. Quite young, and he complained before the Irish Data Protection Authority challenge against the decision of the Commission related to this adequacy decision with the US. At the time, if you remember, Edward Snowden in the US was a whistleblower, and he revealed that the US intelligence agencies were had very privacy intrusive surveillance practices, and they were able to access the personal data of a lot of citizens, not only in the US, but also, for example, through social media in the EU. No? So a lot of personal data of EU citizens were at risk of being accessed by the US surveillance intelligence authorities. And so he challenged the adequacy decision, saying, actually, the level of protection for privacy and data protection in the US is not adequate for the free flow of personal data between the EU and the US. At the time, it was called the Safe Harbor Agreement, this adequacy decision. And the issue was whether there was an adequate level of protection between the two, basically. And the Court of Justice decided in this case, very important case for data transfers, that US law did allow not only did it allow for the mass and indiscriminate surveillance of EU citizens' data, but also there was no safeguards, basically, as I mentioned, for example, with Japan, there were no safeguards for EU citizens to be able to know about this, to complain to data protection authorities or whatever, no? And so the Court of Justice decided to invalidate the safe harbor agreement, and so the free flow of personal data between the EU and the US was interrupted, and there was the need to adopt a new adequacy decision, in which then the EU negotiates with the third country and says your law should foresee the similar safeguards as those in the EU. That's what happened with the conclusion of the EU-US Privacy Shield and the adoption of the Commission adopting a new adequacy decision, which led to a second case because Max Schrems was not happy again with this decision, this adequacy decision. He went to court and he said, no, actually the EU-US Privacy Shield is still not adequate. And he was arguing that US intelligence practices still pose a threat to the privacy of EU citizens. The case actually concerned not only the privacy shield, but also what we call standard contractual clauses that the European Commission can adopt, and that organizations, for example, that companies can include in their contracts related to data transfers, and so to kind of ensure that some safeguards are contractually available for citizens. But the Court of Justice said again, it invalidated the privacy shield, and it said that the US intelligence laws were incompatible with the EU fundamental rights to privacy and data protection. And so you can see how, again, we are really the EU has a rights-driven model because the fundamental rights are quite instrumental in, for example, in allowing or not the data transfers between internationally. No? Anyway, this decision made so that the transfers of personal data between the EU and the US was at risk, but some organizations and some companies decided to continue transfer the personal data of Europeans to the US. That was the case of Meta, which was fined for this, as I mentioned, 1.2 billion euros, the highest fine ever under the GDPR 2 years ago. And that's exactly why they were fined such a large amount, is because there was a systematic transfer of personal data without adequate safeguards to the US. Today, 2 years ago after this, the EU adopted the EU-US data privacy framework for the commercial sector, the private sector, under which, so it's a new adequacy decision for the US, but based on just only for the private sector. And supposedly with sufficient safeguards, but we are never free from an action by Max Schrems on this topic. So let's see. Anyway, as I mentioned, those are the highest fines under the GDPR, and some of the highest, like the one on Meta and the one on TikTok, related to international data transfers. You also have other types of, those are the number of fines, the highest fines imposed in the past years. You see that they all concern big tech companies, so especially Meta, Google, Uber, Amazon, no? Okay. So let's conclude maybe on this first part of the intervention on the Brussels effect. We've discussed the de facto and the de jure Brussels effect. The de facto is when companies, organizations, through market forces, adapt their and align their practices to EU regulations, even though they are not obliged to do so outside of the EU. So a very big influence of EU regulation happening de facto without any constraints. And then again, without constraints, but governments adapting and aligning their regulations to align them with EU ones. We've seen the specific case of privacy and the GDPR, which has had a very important Brussels effect. But you can observe that in a lot of different areas, for example, in antitrust, so in competition, in online platform regulation, in the regulation of artificial intelligence. That was very clear for the GDPR, and that was explained also by the European Commission, for example. Even also India or Indonesia or Japan, South Korea were mentioned as countries which had adopted very similar rules to the GDPR, showing the de jure Brussels effect. And the European Commission, when it is active, for example, with India in the negotiation of free trade agreements, is also concerned about promoting the data protection rules similar to those in the EU, and that's what we can see in different policy documents of the EU. When you actually look at the situation in terms of privacy protections in the world now, those are the different adequacy decisions that have been concluded with third countries. So you see Japan, Korea, and Argentina, Uruguay, and the UK. But when you look at the level of protection across the globe, those countries in red have actually a very similar set of protections than the EU. So India, even China, Australia, and then in North America, very similar protection levels. Yeah, those in the Indo-Pacific we related to privacy. I mentioned already China and India which adopted very comprehensive legal frameworks in the past years. But related to online platforms, you see that Australia has adopted very similar content moderation rules than in the EU. In competition, you see very similar rules in digital markets and cases that are very similar in Japan, in South Korea, in China, and in the adoption of rules on artificial intelligence. Also in Japan, very similar set of rules and the development of similar rules across the region. As I mentioned, there are some, and I will finish on that just now, related, I thought it was important related to India. Recently, there was a recent report by the European Data Protection Supervisor, so it's kind of the data protection authority for EU institutions, that had to decide of whether or not it was authorizing transfers from the European Investment Bank of personal data in several countries, including India, and they did not authorize this transfer of personal data because they considered that the level of protection was not sufficiently adequate. So just to mention this. So this is what I wanted to cover related to the global reach of EU digital regulations through the study of the general data protection regulation. But I don't know if you have any question. I see already a hand raised.
Yes, Venkata Subramanian.
Yes. Yeah.
Yes, you can ask your question.
Anyway, if anyone has any question now, it's I think we can cover them.
Yes, I might have a few questions. Yes, can you hear me?
Yes, yes.
Yes. They're of interest that you highlight the importance of the internal market approach. So the GDPR was based upon this Article 114, which is a central provision in the treaty because it empowers the EU institutions to adopt any kind of act related to the establishment and the functioning of the internal market. So the common market, when it was designed in conceived in 1957, it was not supposed to encompass data protection. So it's interesting that in the 70 years, new areas have been catch up by these kind of broad provisions. But I have two questions. In the beginning, you were stressing the difference between the US approach and the EU approach. So the US, in a nutshell, favors, or at least authorities and businesses favors freedom of expression to the utmost, kind of limitless freedom of expression, whereas in the Europe, the protections of children, of minorities, the fight against discriminations, the right to privacy is subject to a high level of protection. And so you were mentioning this weighing of interest. Could you provide one or two examples that could highlight us about this difference? And secondly, you mentioned in the scams case the review by the Court of Justice of the adequacy of an European decision, or European Commission's decision to acknowledge that the US system was providing for the same level of protection than under the EU. And so a bit of naive questions. So a European court has to decide whether the US system is adequate enough to afford a protection. So firstly, a court is not endowed with so many technical or technological means to to understand the issue, and then it's a bit extraterritorial because the Court of Justice had to really to delve into the US legal system and to reach a conclusions. So whether criticism from the US government or US academics in connection to this judicial review.
Thanks a lot for the great questions and complex ones indeed, because I mean, we could discuss them for hours. First, I mean, your first question on the idea of, I found the protection of free speech in the US, and maybe differences between the EU and the US on that topic, if I understood well. Actually, and I read the judgment of the Supreme Court of the US related to TikTok. You know that it's maybe one of the last developments in the area, which I thought was very interesting, especially to kind of show that those models are not necessarily absolute, no. So in the US they adopted, you know, that they adopted a law which would ban TikTok if TikTok was not
Purchased
purchased by an American company, basically, or a non-Chinese one. and the case, obviously TikTok appealed that, wanted to annul that law, and the case reached the Supreme Court, and actually the Supreme Court is, even though that implies a lot of important, there are lots of implications in terms of free speech, no, because you would potentially ban a very important communications means in the US with millions of users. The Supreme Court kind of sided with Congress on this issue, and so there are exceptions also, even in the US, no. And that shows also the kind of, if you want, this in this instance, the US also has adopted kind of as you see on the slide, a more of a state-controlled approach on this issue, compared to anyway. For your question on no, and I mean in general between the US and the EU on these issues and the protection of free speech, the new rules on the online platform regulations adopted in the EU have been very criticized from a US point of view, because they see those rules as an infringement on free speech, that the EU is imposing very heavy content moderation rules on US companies and US tech giants. Actually, we will see tomorrow that it is not necessarily the case. The EU is not saying to companies what they should or should not actually host on their platforms, but there are a certain set of obligations to ensure accountability, transparency and accountability for those platforms. But we will discuss that tomorrow. But in general, yes, the EU approach is very criticized in the US. Related to your second question on judicial review of those adequacy decisions, in the end, the Court of Justice is looking at the surveillance laws in the EU, in the US, no? So they are not necessarily looking at the possibilities from a technical point of view, or from but they are looking at what the law says in the US in terms of possibilities to surveil the personal data available by the tech platforms and stuff like that.
But there was a security issues. I think it was the CIA in the first judgment, was the CIA and FBI endowed with wide power to search through the data gathered by Facebook at that time. Was it Google?
Yeah, and the NSA. Yeah, but the Court of Justice is looking at the possibilities in the law there. Yeah, I don't know if that answered your questions.
There was a question on the screen. Okay, can you read it, Sebastian?
Wait, I'm not sure.
Are there any specific instances of national level barriers that affect startups and digital service providers within the EU internal market, despite having a broad and harmonizing regulation like GDPR? It's from Khatskana.
Yes, I'm looking at the chat, but if you have any questions that you want to ask orally, there's no problem. Please allow us to unmute. You cannot unmute. Maybe that's something that wait, are there any specific instances of national legal barriers that affect startups and digital services providers within scaling abroad and harmonize? Yes, yes, you could have national rules, and that you recently also there was a case, for instance, before the Court of Justice on Italian measure. Italy wanted to adopt. I mean, I don't know the case in big details now, but Italy had adopted, for example, content moderation measures for social media and stuff like that. And the Court of Justice said that they could not adopt specific rules on this. So yes, you have sometimes instances of national of member states adopting rules that could hinder the free movement of digital services between in the EU, no? And that's also why the European Union adopted those rules on digital platforms at the EU level, because you had a lot of different member states adopting rules that were sometimes contradicting, and so that you could sometimes that could hinder the free movement of digital services. No, I don't know if you want to compliment me, Professor. Does it cover fiscal provision? Does Article 114 cover fiscal provisions? Actually,
No, it's not the case. I can answer to you. There is a specific provisions regarding taxations. It's 113, and 113 provides for a special legislative procedures. It means that only the council can adopt the directive on VTA on taxation, and so the European Parliament cannot co-decide with the Council of Ministers. So it's the European Commission proposing exclusively to the Council, and the Council decides. So it's a whole-fashioned procedures, and that means that every state has a veto power, is vested with a veto power. So it's very difficult to reach a full unanimity in deciding sensitive fiscal topics. So that's one of the weaknesses of the internal market. So the internal market is very robust when it comes to protecting consumer interests or business interests related to goods and services. So here we had no shortage of illustrations regarding technological services. There are no shortage of illustrations when it comes to goods and substances, be it cars, be it GMOs, be it tools. However, when it comes to taxations, Europe is fairly weak. And that explains for Indian businesses wanting to invest in Europe. Belgium is not the best place to invest from a fiscal point of view, but from for the quality of the labor force, the competence of the labor force, the network of transportation means, the location of the harbors. Belgium is privileged by many Chinese or Indian investors. But on the other hand, the labor force is more expensive, and taxation is somewhat higher than in other European countries, because there is no harmonization.
Okay, sir. Shall I ask another question, sir, with your kind permission?
Yes, please.
Yeah, of course.
Okay, sir. That is it possible to make a trade agreement that also deals with regulatory or investment issues between the European Union and a third country? Third countries like India, just
Professor?
that is a mixed agreement about. That is about a mixed agreement, sir.
Professor de Sadeleer, I think it's a question that is more.
Okay, can you repeat the question?
Sir, shall we make a trade agreement that also deals with the regulatory or investment issues between the European Union and the third countries?
Yes.
That mixed agreement like that.
Okay, as I explained,
Yeah.
in brief, the powers conferred to the EU institutions when it comes to regulating foreign trades are very wide. So it encompasses trade in goods and services without de minimis rules. So a treaty can be conceived regarding agricultural goods or industrial goods but most of the recent free treaties encompass nearly all services and all goods. But it means that the EU and the third country can negotiate also the tariffs. So the tariffs will differentiate from one treaty to another treaties, and there are also quotas. And the quotas are necessary for the EU because, for instance, the car industry is more vulnerable. In particular, if the treaties conclude with a third country whose cars production is cheaper. When it comes to investment, there are very few EU treaties that have been concluded. So it's mostly the member states that have been concluded more than 1,200 bilateral treaties on investment protection. Mostly the aim was from Western nations to protect their investors in Congo, in Chad, in Cameroon, in Senegal, because there were doubts regarding the independence of the judicial system. Now the EU has the power to regulate not direct investment. So the portfolio investments are falling outside the competence, not an exclusive competence. But now for this last 12 years, there is a competence. So far, there is a chapter in the CETA treaty, the treaty concluded with Canada, that regulates the rights of Canadian investors in the EU and the right of European investors in Canada, and they provide for that the disputes between the investors and the host countries should be settled by a specific Canadian EU court. So there will be half of the magistrates will be appointed by Canada and the other half by the EU. And the court is organized similarly to a more classical traditional court, the judges being independent, being appointed for long terms, being appointed to hear a number of disputes. So it's a very different approach from the traditional ISDS approach. And besides, there is the investment agreement with Singapore. And these be the chapters of the CETA and the agreement of Singapore, they are not yet in force. Why? Because it requires as a matter of competences, it requires the approval of the national parliaments. So it's not anymore an exclusive competence because the judicial proceedings touch upon justice, and the judicial system is part of the sovereignty of the member states. So the EU cannot harmonize the judicial system. So the ways in which the courts are organized is left to the states. So the EU cannot mingle with the judicial organization, whether there is a commercial court or labor court or labor court of appeal. And so given that this investors, host countries dispute part of the judicial system, that requires that every member state approves the investment treaty. And that's not explained at all. I looked at the different EU websites regarding the negotiations. So they mentioned 3 treaties, but they don't mention the complexity of the EU institutional issues. So just bear that in mind. That it will be easier for the EU to conclude the trade treaty, whereas it will be much more difficult to conclude the investment treaty. But again, I need a bit of time to adjust my slides because it's while we are teaching and answering the questions that we realize that there is constantly a need for clarifications given the sheer complexity of the institutional schemes.
Yeah. Thank you very much, sir.
Hello, sir.
Yes.
May I ask a question, sir, if you
Yes,
permitted
please.
me?
Yes.
Sir,
very
in starting, you explained the three models of European and the America and the China. So, what is the differentiate between the among the three models, sir? First, you told that the America is the working for the betterment for the peoples, and second, you explained the China model, and third, you explained the European model. So, what is the key features of the differentiate? You have to be explained, sir.
Okay, yeah, I mean, very to come back very quickly on this. The main differences, if you want, between the three is that in the US, generally the model is focused on markets and on free markets, so on not regulating too much, on letting companies freely innovate and freely deliver their products and services on the market without state interference. The main way of the US model to spread globally is through its private companies, no? And we see that with the big tech giants for that reason. And then in China, if you want, the focus very briefly is on state control. So on the state controls in terms of, for example, subsidizing the infrastructure companies, the digital infrastructures companies, the big tech giants in China, but on also keeping a close eye on what is done in terms of in terms of the exploitation of personal data, in terms of competition in China. So quite a lot of state control. And then in the EU, a focus on fundamental rights and on providing individuals and companies rights that are adjudicated ultimately by courts and which are enforced by a complex set of enforcement mechanisms. So that's a bit the three, and we've seen with the Brussels effect that then for the EU, for example, this how it spreads its power in terms of regulation of in the digital realm is through its rules and through its regulations, and so that's why I mentioned the GDPR, because then we've seen that the GDPR is a very clear example of the Brussels effect, of the ability of those EU norms to influence the adoption of similar norms in the outside of the EU, and also compliance by companies even outside of the EU. Does that answer your question? Like in a nutshell, I would say this is the argument in Bradford's book, Digital Empires, but obviously this can be criticized, this can be challenged, and also, as I mentioned, also they are not absolute. So the US model is not absolutely a market-driven model. The EU one is not an absolutely rights-driven model. But yeah. Okay. Any other question? I see another hand raised. Several hands. Go ahead with your questions. Don't hesitate.
Yes, Mr. Kwadam. Is there any technical issue?
Yeah. I don't see the chat. Wait.
no.
I'm not able to unmute.
Yeah.
Okay.
You can ask.
But for me, everything is perfect.
For everyone, it's supposed to be perfect.
Yes, I think it looks very perfect, to say the least. Could I propose that we take a 12 minutes pause?
Yes, sir. We can take a.
Yes. So
Sure.
there is still Mr.
Do we-
Chaudhary.
Do you
Yes.
want to deal with we can try to Lois to unmute, yeah. So let's see maybe with this and then we do a break or.
Maybe I prefer that it has been lasting 2 hours. I think everybody needs a break now.
Yeah, I'm just concerned with the questions of everyone.
If you're
No.
if you're not able to speak, you can type your questions.
Yes, that will be easier. And then we just take the break and a good idea, and that participant can forward us their questions. So we restart in 12 minutes.
Okay.
Thank you.
Yes.
Could you? I just have
Good
a question.
afternoon,
Could
sir. May I ask a question?
Yes, please.
Of course.
My question is to Mr. Sebastian.
Yes, to Dr.
Yes.
So my question is, given the dynamic nature of data protection, so how can organizations in general, implement a unified and adaptable data governance framework, which could simultaneously address the distinct requirements of global regulations, like for example, EU's GDPR and India's DPDP Act, and at the same time, how can it mitigate the risks posed by emerging AI technologies and also the sophisticated cyber threats as such. Also, on the other hand, how can these acts like DPDP or GDPR build a genuine user trust?
Thanks a lot for the question and that's I mean those are very broad questions, indeed, because I mean the compliance with the GDPR is a complex issue, and it encompasses a lot of different practices and areas. So it really depends also on the type of data processing that is at hand. No? So it's very difficult to give a very general answer to that. Maybe in your question related to AI, I think then that tomorrow I will give more explanations on how the GDPR is actually used and has been the prime regulation to regulate AI systems up to now. Because I will present also the rules adopted very recently last year by the EU with the Artificial Intelligence Act. But actually, it's not the first set of rules that apply to AI systems. So the GDPR, and I've made some studies on that the GDPR has been the most important regulation in terms of regulating AI systems. Yeah, just to come back maybe on what I explained previously related to the Brussels effect, but the fact that the GDPR is some of the strictest rules in terms of data protection and privacy, it's precisely because of that a lot of countries and companies apply the strictest rules, being those of the GDPR, no? But then the questions of compliance are very complex, and it's always developing because it really depends on the sector and the types of processing activities. I don't know if I answered your question sufficiently, but it's a very broad one, so it's also complex to address.
I might complement. I stressed yesterday that even when the subject matter is extensively harmonized, as it is the case of GDPR, the EU must reckon upon national authorities. So I gave you the illustrations of the custom code that must be implemented by the custom authorities in every country, because the control is taking place at the border. When it comes to the enforcement of the GDPRs, the disputes between the users of the electronic means and the companies must be resolved at domestic level firstly. And so there is a national control agency in every member state. And then in case the claimant, the litigant disagrees with the decisions endorsed by the national agencies, questions, it will go to court, and this court can cooperate with the Court of Justice in Luxembourg in referring questions for preliminary rulings. So that's why in the scam case was actually an Irish case. The student who was based in Ireland, he was studying in Trinity College. He was dissatisfied by the answer of the national control authorities, and he went to the High Court and convinced the High Court to raise the issue before the Court of Justice. And then the Court of Justice said there is a major problem with the ways in which the American agencies interfere with privacy and privacy of Europeans. So yeah, so this is again a good illustration of what was stressed. There are very few civil servants working for the EU institutions, 35,000, 40,000 maximum. So so when it comes to implementation, everything is reckoning upon state authorities.
Yes, and in the specific case of the GDPR, there's also a cooperation mechanism between those national authorities. So they in case of disagreements between authorities, there's a kind of a conflict resolution mechanism at the EU level. For example, because a lot of companies, big tech companies, are established in the EU in Ireland. The Irish Data Protection Authority is the lead authority for those companies, so they should in priority take cases that have for those companies. But there's a possibility with the European Data Protection Board to actually address concerns when other data protection authorities think that the Irish one or another one does not address compliance properly, does not enforce properly the GDPR. Sorry. I see other.
Sir, that being said, how can the GDPR differentiate between the personal data and the sensitive data vis-a-vis the data protection and the privacy shield as such?
Sorry, what is the question? The difference between
how the data protection differentiates the privacy shield under the context of personal data and sensitive data.
With the US, so the EU-US privacy framework for international transfers, you mean?
Yes.
Yeah,
But there is a distinction between the general personal data and the sensitive data. So though protection or like privacy shield is ensured by EU, how will it differentiate and how will it properly bifurcate the rules of data protection and right to access information or right to consent to it as?
Yeah, I'm within the EU-US privacy framework. So the ability to transfer data from the EU to the US and vice versa. I'm not sure how there is a differentiation between sensitive data and other types of personal data. I'm actually not sure whether there's a difference. What the extent to which there is a difference, so I couldn't properly answer that. But in general, it concerns all types of personal data. So yeah. But I'm not sure what are the differences in terms of with sensitive data, which are but in general. So just maybe then under the GDPR to answer obviously, and it's probably like that in India too, but there are specific rules on the idea is that sensitive data, so related to sexual orientation, political affiliation, race, stuff like that, are in principle prohibited. It's prohibited to process those types of personal data in principle under the GDPR, except if data subjects consent or except if there are other types of exceptions like legal obligations and stuff like that. But I'm not sure within the data transfers how that plays out actually. I will have to look it up.
Maybe I have a question. So it seems to be that the companies provide the right to consent to the customer. But in many cases, it seems to me that many customers just give up their right to privacy in allowing the companies to use commercially their data. So what will be, do you have any idea about the real impact? Because when I want to avoid to give my consent, it requires to go through a specific procedure that's quite time consuming. Can you comment upon that?
Yeah. I mean, it's a very big issue. The fact that actually in the past years there's been a lot of debates and controversies around the ways that big tech companies are and not only big tech companies but a lot of firms online are trying to circumvent consent requirements basically. So they create what we call dark patterns with their user interfaces to try to influence the choices of consumers on whether or not to be tracked online and stuff like that. And so there's been a lot of, and maybe I can discuss that tomorrow when we discuss artificial intelligence, but there's been a lot of enforcement actions using the GDPR to try to curb this. Because the data protection authorities were actually looking at how the designs of the user's interface were made and trying to avoid that those designs would influence the choices of users. It's been addressed a lot with the GDPR exactly. But it's an ongoing concern, especially because, and I discussed that in my thesis, but my dissertation, but even if consent is not influenced in one way or the other, I mean, if the decision is not influenced towards consent or towards, usually towards consent, the big question is whether or not users actually understand the whole scope of the data processing that is being done after that. So even if they accept, do they actually understand what is what they accept, what the extent of the data processing? So there's a lot of criticism sometimes also of the consent requirements under the GDPR because it's very complex what is actually at stake with the tracking and the profiling online. I see there's a comment on.
Perhaps I propose that you continue because there's still so much materials.
I just have a question. Could you see my slides in the previous session before? Could everyone see my slides? Or was I just... It was visible. Okay, so you could see them. Thanks. Well, now I guess you can, but let me know if not.
Yes, I can see them. It's perfect. No.
Okay, then I will I will continue then on sorry. Okay, so we've done the first part about the global reach of EU digital regulations and through the study of the GDPR. Now I will try. So we how much time do we have now?
We have 1 hour, 30 minutes.
Okay, perfect. So then, and we can make a break after this second chapter if you want.
Yes.
About the the EU's digital strategy. So I will very briefly explain the EU's digital strategy in general. So it's a very broad strategy, as you can imagine. I've already discussed some regulations in terms of data, but there's regulations in terms of infrastructures, in terms of the specific actors and specific practices. But I will now explain more the policy side of things and what is the general strategy. So it will be maybe a bit less legal, and you will see that it's more of a policy as policy objectives, but we can always relate that to the legal discussions, no? So in general, and I'm here really referencing to the strategy of the EU in its policy documents, but the European Commission presents in general digitalization as both bringing opportunities for people and businesses and implying a lot of different risks. With the opportunities, obviously, we see that digitalization can bring us together, just like in this teaching module, with in different time zones and different geographies. So it's actually a very good opportunity, and we've seen that also during the COVID pandemic, obviously. But the European Commission also sees digitalization as an enabler of rights and freedom. So, for example, access to public services through digitalization, stuff like that. And for businesses also, the opportunity to access new markets, to develop new markets. No? In terms of risks, I think we all know a lot of the different risks that are and the vulnerabilities of digital spaces. There are examples also of disinformation, misinformation, the spread of harmful and illegal content online, for instance, and we will discuss that tomorrow with the regulation of online platforms. In the EU, we've had a case of interference with the elections in Romania, for example, that happened online, with the elections that happened very recently, and Russian interferences in the elections. So there are risks in terms of digitalization. There's also very low competition levels in many markets. If you look at at the market for clouds, for instance, at the markets for even social media you could discuss, but search engines, you have very low competition. Google has 90% of market shares in the EU in search. And in many markets, it's the case. You also have the cyber security risks due to digitalization in a number of critical infrastructures, for instance. So yeah, a lot of different risks and opportunities, but the EU in its digital strategy is betting a lot on digitalization, mainly through 4 axes. And I will focus on 3 of them after this, based on a more general overview of the different policy strategies. But first, the EU wants to develop the skills of millions of citizens, so that they are able to work in an environment that is highly digitalized, but also that citizens in general can have access, have high digital literacy skills. In terms of infrastructure, and we will discuss this after later today about the semiconductors, but there is this willingness to first in terms of connectivity, so enable high-speed mobile coverage, at least with 5G throughout for everyone in the EU, but also to ultimately produce an important a percentage of semiconductors in the EU. We will discuss that with the CHIPS Act. To develop supercomputing capabilities throughout the EU, and that has been the case in the past years, and I will mention it. Develop the digitalization also of businesses, so that's a third axis. To have not only big companies but also SMEs take up the digitalization of their businesses, and to also create the ecosystem for startups to develop and to innovate in digitalization. Then there's a fourth axis, and maybe we will discuss less about this, but the government and public services. So having 100% of key public services digitalized. There are discussions about a possible EID in the EU, allowing to access public services online more easily, and also throughout the EU. Discussions about health records of citizens being able to be exploited online. Online, sorry, to be able to be shared, so that, but we will discuss that again later tomorrow. So if you look at I looked at different policy documents of the European Commission, which basically for the past 10 years have been developing quite extensively, and those policies have been translated progressively into regulations, mainly regulations and a bit less directives in the past years. Related to infrastructure, sorry, there is this the willingness to guarantee first the sovereignty of the EU in terms of infrastructure. So that's why there's a strong focus on localized production of semiconductors within the EU, and we will discuss that because I think it's a very important topic. But also to develop connectivity with internet infrastructures, with mobile infrastructures, to enable cooperation between member states on a number of topics. So, for example, there's been the creation of a joint undertaking for the development of supercomputing capabilities. And there are supercomputers in different parts of Europe that can be used by not only public authorities but also companies to innovate, to create new products and services, and in general to help the green transition. I mean, to use digitalization also for the green transition, and to kind of proceed to a green transformation also of the IT sector. In terms of skills, and that maybe the recent developments in the US could go in the direction of the EU trying to bet on education and on digital skills, and to avoid, for example, brain drains also. So a lot of, if you look at, for example, AI development in the EU and research and development in AI, a lot of AI researchers based from the EU are actually leaving and going to the US, for example, and maybe recent developments in the US might reverse course on this. But to develop basic, also not only advanced skills within the EU, but also to enable everyone to have a basic set of digital skills and literacy, to reduce the shortage of workers with adequate digital skills, to enable everyone to enter the job market with digital skills, to make sure that the platform workers, I mentioned previously the Platform Work Directive, which was adopted last year, which ensures that the the workers that are employed by, that are hired by the online platform. So, for example, delivering food, delivering, for example, taxi services based on online platforms also, that these workers have an appropriate level of protection for their in their working environment, and that are not necessarily the new rules is that they should be employed by the platforms and not be hired as a self-employed workers. Anyway, to also develop the digital skills of women, and to have the necessary R&D in those in this area. Related to the economy, tomorrow we will discuss a lot about this today too also. But obviously, there's this huge importance of data, not only personal data, but also industrial data, public data, and that we will discuss tomorrow with the EU's data strategy. Yeah, to create the conditions of a digital single market, so to avoid to avoid inconsistencies in the laws of member states related to the digital economy. That's why also there's a lot of legislative activity in this field recently, and to ensure that the economy not only is growing, but also is growing in a fair way, in a competitive way, and in a trustworthy way, so that consumers trust the products and services that they use, so that competition is guaranteed to enable innovation and to avoid the exploitation of consumers, to ensure that intellectual property rights are respected online, and stuff like that, no? So there's a lot of rules, and I will explain some of them between today and tomorrow. To guide, if you want, the digitalization of the EU's economy, the Parliament and the Council and also the European Commission adopted the European Declaration on Digital Rights and Principles for the Digital Decade a few years ago. And it's basically a joint declaration. So it doesn't have the same force as the fundamental rights in the treaties, for instance. It's an interinstitutional declaration, but it's setting principles reflecting the rights and values that are intrinsic to the European way of conducting this digitalization of the economy and the public sector. We won't go through the different rights and principles that are enshrined in this declaration, but those are the main six focus to enable people to have rights, to include everyone in this process, and to not leave. That's why there are lots of work being done about digital literacy, digital skills of people, to enable the freedom of choice of individuals, not only consumers, but also citizens when they face public services, to make sure that the digitalization of the economy also serves the sustainability principles and sustainability objectives. In the previous commission, especially the previous commission, and Professor Sadeleer would comment a lot on the Green Deal, and would be able to give a much broader, a much better explanation than me. But the idea of the previous commission was to develop at the same time both objectives, the digitalization of the economy and the green transition at the same time. now maybe that, well, there are nuances today with the new commission after the elections of last year as to the Green Deal. But also the guaranteeing the safety and security of people, especially children. One of the objectives of the EU of the Commission in this mandate is to also protect children online. And yeah, we will come back on that related to online platforms with very important rules related to the protection of children. And finally, to enable citizens to participate in the democratic process through digital tools. There was a small video, but I think I will just skip it. Oui. So how is that relevant? How are those rights and principles relevant for the Indo-Pacific region? Well, actually, if you look at the partnerships of the EU with some countries in the Indo-Pacific, for example, here Korea, you see that both partners, there was this declaration last year that both partners were sharing the visions enshrined in this declaration of digital rights and principles. And so it made me think of the Brussels effect, no? Because it's also through cooperation mechanisms between those jurisdictions, with third countries, sorry, that those rights and principles are also being expanded abroad. I mentioned already the double objective of the digital transition and the green transition. And I already mentioned that within these policies, a lot of regulations have already been adopted. And after this, I will mention the European Chips Act, trying to develop the production of semiconductors within Europe. What is the global dimension apart from these declarations with Korea, for example, that both partners are committed to the digital rights and principles? What is the global dimension of this of Europe's digital transition? Well, when you look at the cooperation first with third countries, there's this influence of EU principles and rights. So there's a clear influence, but also the EU is active, is cooperating in different international bodies on implementing them and on influencing their adoption, not only with third countries but also internationally. So within the UN, the OECD, when developing standards that are also adopted by other organizations in third countries, and through the G20, for example. Related to the Indo-Pacific and the impact for the Indo-Pacific region, and I will mention specific EU-India relations now. Obviously, there are collaborative opportunities in digital innovation and technology between the EU and Indo-Pacific countries. So, for example, related to research, to connectivity, to standardization. Yeah, obviously, if companies from the Indo-Pacific region want to access the EU market, it becomes more and more relevant to properly understand and comply with EU regulations in this space. And that's why also I think it's a timely moment for this type of teaching module. And obviously potential partnerships in terms of infrastructures, in terms of digital skills training, cybersecurity initiatives. And when we will discuss the CHIPS Act, you will see that there are lots of opportunities for Indo-Pacific companies from countries in the Indo-Pacific to invest in the EU for the production of semiconductors. When you look at the relations between the EU and India, because Professor de Sadeleer already introduced the topic in the previous session, the EU and India have been cooperating within the Trade and Technology Council, a council, a relatively new framework where the two economies are cooperating on a number of issues related to the economy and technologies. The last, Professor de Sadeleer already mentioned the last meeting that happened in February in Delhi. And when you look at the details of this cooperation, there's a lot of cooperation related to strategic technologies, to digital governance, and to digital connectivity. For instance, even the AI office, the European AI office, is collaborating with the India AI mission and to try to cooperate on the regulation of large language models, for instance, and other AI models and AI systems. And also I mentioned semiconductors are a very critical and strategic infrastructure in today's economy. And so there are the cooperation in terms of research and development in the field of chip design between the EU and India. So you see that there's a lot of opportunities, even in terms of supercomputing capabilities, of connectivity in terms of 6G between the EU and India, and there is scope for more cooperation probably. Let me give you an example of how, and a very concrete example this time, of how the EU standards and EU regulations can, in the digital sphere, influence also, not influence, but influence standards in the Indo-Pacific and region. In 2014, the EU adopted a directive called the e-invoicing directive, trying to improve invoicing between companies in the EU within the internal market. So yeah, you think it looks like a very internal affair, no, between the different member states of the EU. Why? Because invoicing takes up a lot of time of companies and try to use digitalization as in a more efficient to have the invoicing much more efficient. The EU adopted this directive, and so member states adopted different national rules to implement it. And it was meant at the interoperability of invoicing systems between member states. That led to the development of specific standards, and so progressively you have now all member states have transposed that directive, and it is now the majority of member states even made it mandatory for suppliers to issue e-invoices for when they deal with the public sector, for example. And so instead of having paper invoices in a lot of different sectors and areas of the economy, you have the possibility to e-invoice with specific standards, no? So that's part of the digitalization, the strategy of digitalization of the EU economy. It's a very specific example, and it's just like to show you the impact that it can have abroad also, because what the European Commission has done is that after this, it actively promoted the adoption of the same standard abroad. And so today, and you see in a report from the Commission that some countries in the Indo-Pacific have adopted actually the same standard. And so that is the case of Australia, of Japan, of Malaysia, of New Zealand and Singapore, and they adopted exactly the same standard so that their companies and European companies can e-invoice between themselves using the same standard, and that obviously helps. I mean, it maximizes the investment of EU companies in those systems to use them also with companies located abroad. And also it helps those companies located in third countries to do business, and it renders business more efficient between those companies. So ultimately, it's benefiting both partners, and it facilitates international trade. It's a very good example of de jure Brussels effect. This time related to a very benign or trivial, if you want, issue of invoicing, but nonetheless very important to digitalize the international trade. So this is a bit what I wanted to. It was not very legal and it was more policy oriented. What I tried to explain. But I thought it was important before we delved into more specific issues to give you a very broad perspective of what the digital strategy of the EU is. It's not only about rights, as we've seen with the previous model that I showed you, the rights-based model. It's also betting and investing heavily on critical infrastructures for the digital economy, like connectivity, like supercomputers, like semiconductors, which are necessary for the development of digital technologies, and also obviously adopting rules to enable innovation, to make it easier for companies to innovate and to trade between member states and with third countries, and to protect consumers, protect workers, and to protect citizens when they face digitalized public services. So this is a very broad perspective, a very broad view, and I don't know if you have any question before we delve into more details with the European Chips Act, which I think is a very good example of how the EU is also investing and very heavily in digital infrastructures. Please let me know if you have any question, and I'll be happy to answer. And I realize it's already 3:30. Any question? No? It's already 3:30, so I'm actually not sure if we have time to 3:30 Belgian, European time. So I'm not sure if we have time to go.
We have 1 hour more, sir. Exactly.
1 hour to go? Okay. Okay. Anyway, if there's no question, I can continue, obviously, huh?
Or you can take a break if you're tired.
No, I'm okay. But okay, then we can continue if there are no questions. Let me just keep track of time this time. Okay. So after this very general introduction, you can see that the EU's digital strategy encompasses a lot of different areas. We will focus now today for this last chapter on the digital on the regulation of digital infrastructures, and actually more than regulation, it's the investment possibilities in digital infrastructures, no? And we will see that clearly impacts. I decided to discuss the European Chips Act, because just like the US Chips Act, it does influence a lot what is being done in terms of semiconductors in. Okay, so digital infrastructures, it's not only microprocessors and semiconductors, it's also developing connectivity with mobile networks and general broadband internet, but also supercomputing capabilities and even the development of quantum computing. So at the EU level, there's been the development of the European High Performance Computing Joint Undertaking, which enables its cooperation between European states, but also states outside of the EU. I think Turkey is part of this joint undertaking, for instance. Cooperation on the investment for high performance computing capabilities. Today, the EU has 12 supercomputers. One of them is located in Barcelona here. And it's actually in an impressive building and in an impressive capability. And those supercomputers are also used as what the European Commission calls AI factories, where public administrations and companies, private companies, can use those facilities to develop, for example, AI models, and that they can use them to develop new products and services. No. There's substantial funds allocated to these to the development of these supercomputing capabilities, not only from the public side, but also with the cooperation with the private entities. That is why the EU created this joint undertaking, because it allows for a private cooperation and partnership. Those are the locations of the supercomputing capabilities and quantum computers in Europe. Yes. And so let me now discuss the specific case of semiconductors, no? Because to develop all of these supercomputers, you need a lot of very advanced chips and very advanced semiconductors. And last year, NVIDIA, the US company, became actually the world's most valuable company. I don't think it's the case anymore this year, but still it is it showed that the semiconductors had become a very key asset and a key infrastructure for the development of the digital economy and digital technologies in general. No? Why did that happen? How did that happen? Well, let me give you the context actually related to the manufacturing in Europe, both in the EU and in the US. There's been this realization that a lot of, as a critical infrastructure for the digital economy, semiconductors were mostly produced abroad. In 2022, the EU's share for the global microchips in the global microchips market was only 10%, and it came from much higher levels before that. When you look at the 90s, in the 90s, around 44% of the global manufacturing capability was located in Europe, and around 40% was located in the US. And it clearly changed, and most of the manufacturing capability is now located in Indo-Pacific countries. So what has the EU done? First, it analyzed the situation, and I will explain now how what is the situation and what the EU has planned to do to remedy some of the risks that it identified. No. So as I said, semiconductors are essential for manufacturing. Sorry, it's essential in a number of products. No, so not only electronic consumer electronics, but also in cars. You look at cars now, at medical devices, at telecommunications, robotics, in aerospace, in defense, in energy. Semiconductors are everywhere, and they are now considered a critical infrastructure. And in 2020, between 2020 and 2023, there's been a huge global shortage of semiconductors. That was due not only to the pandemic, which completely disrupted the supply chains and the logistics in semiconductors, but also the China-US trade war, and there's been in 2021 a severe drought in Taiwan that impacted the manufacturing of semiconductor, and today most of the a lot of the manufacturing is done in Taiwan, and so it clearly impacted the shortage of these semiconductors. As I said again, today less than 20% is produced in Europe, and the US, and most is produced in Asia. But the EU identified key sectors in the supply chain of semiconductors where it was still a very important player. For example, in the manufacturing equipment, so the machines that actually produce the semiconductors, the EU still has key actors that are manufacturing those equipments. So, for example, ASML is a Dutch company, very important company, because it develops and manufactures the machines that produce some of the most advanced semiconductors. And actually, it was the US was able to influence the Netherlands to secure a deal so that those countries, the Netherlands and Japan, would not export or would limit their exports of those machines to China, which led to a dispute before the WTO, also due to the US measures on semiconductors and related to China. So that's the China-US trade war. And this is the general context in which the EU adopted the European Chips Act. It also conducted a survey between the market actors in 2022. It commented and it observed the survey made clear that the global market for chips would expand exponentially in the next 10 years, especially due to the development of artificial intelligence, and edge computing, so having computing facilities at the edge of users and not directly with them. And the digital transformation in general. No? So after obtaining all of these responses from manufacturing companies, the EU realized that the chip demand would actually double from between 2022 and 2030, that there was a shortage of qualified labor, and that government regulations were still key when selecting manufacturing locations. That the supply crisis of the years that I mentioned between 2020 and 2023 actually impacted a lot the ecosystem, and that there was a need for funding for research and development in this sector. No, those are the projections for the chip demand in the next 5 years now, and with needs in electronics, in transport, in health, in energy. So what is the European Chips Act? The European Chips Act is basically setting an objective for the EU. The objective is to have a target of 20% for the EU's share in the world production of cutting-edge semiconductors by 2030. So there's still 5 years left, but it's kind of more than double, if you want, the shares of the EU in the production of semiconductors, so that the EU lowers the risks of having the production, for example, in Taiwan or in Korea, or in other countries, and to avoid to gain more sovereignty in terms of this critical infrastructure. No. It was really rapidly adopted, and it entered into force in 2023, so a few years ago. And there are similar initiatives. I already mentioned the US, but obviously there are other similar initiatives in China, in Japan, in South Korea. And substantial funds will be allocated to this initiative. The EU announced at the time 43 billion euros of public and private investments in the production of chips in the EU. What I think is very important to mention is the legal basis on which the European Chips Act were adopted. The EU, so the Council and the Parliament adopted this act based on two legal bases, just like the GDPR. The GDPR was Article 114 of the TFEU, so the harmonization for the internal market, the well-functioning of the internal market, but also, and I thought it was interesting to mention, the competence which is actually a competence that the EU does not use too much, which is the Article 173, paragraph 3 of the TFEU, in terms of industry. So in terms of industry, it's a competence that is not even shared with the member state. It's a competence where the EU can support member states in their industrial policies. And so I thought it was interesting to note that this European Chips Act was adopted on the basis of both legal bases. Why? Because at the same one of the objectives of the European Chips Act, and that's also a way in which the EU is actually supporting member states in their industrial action in promoting the production of semiconductors in Europe, is that the EU is adapting its stated rules in terms of production of possible state investments or state aid in different ways for the production of semiconductors in Europe. What are the stated rules? It's those competition rules that, in principle, prohibit and clearly limit the ability of the state to aid private companies in their economic activities. So, for example, in order to avoid distortion in competition on the markets, member states cannot subsidize specific companies. They cannot give tax breaks to specific companies. And they can, and so there are very strict rules in what can be done within the EU in terms of state aid to avoid distortions of competition between member states. No, if the French state starts to heavily subsidize some of its industries, it would create an unfair advantage of French companies acting in other markets of the EU, in other member states of the EU, and it would create a distortion of competition between member states. And so to avoid this unfair competition between member states, those state rules were adopted. And they've been in place for decades. And what the European Chips Act is doing, obviously there are exceptions. There are exceptions in terms of what states can do. And the European Chips Act is also creating, adopting its state aid rules to facilitate the development of investment and state aids for the production of semiconductors. So I thought that was a very significant development in terms of state aid rules. And what else is the European Chips Act doing? And I will mention some of these investments afterwards. It's also creating a mechanism to prevent and manage the supply chain crisis that could happen, as we've lived in the past few years, and also to ensure the protection of IP rights, of intellectual property rights, resulting from EU funding in those production facilities. What is the international dimension of this act? Well, obviously, in the end, if you look at the general scope and the general objective, the European Chips Act will attract and is already attracting a lot of companies, not necessarily European companies, but also companies that are already major players in the production of semiconductors, like Taiwanese firms or Intel, for example, or other American firms, to heavily invest in the EU. As I said before, and I anticipated, the US, China, Japan, and South Korea are doing the same, or very similar, taking very similar initiatives with other means than the EU. And in the US, for example, the CHIPS Act allocates more than $52 billion to manufacturing and R&D until next year. In China, there are investments of $150 billion on made in China, on the production of semiconductors in China. In Japan, the numbers are a bit less, but still very high. And in Korea, in South Korea, the state is even investing or facilitating the investments of $450 billion in R&D and manufacturing until 2030. So much more than the 10 times the 43 billion of euros in the EU. So very similar initiatives abroad, including in the Indo-Pacific region. Those are the stated rules that I mentioned, the treaty Article 107, which limits the ability of states to invest, with exceptions. And when you look at the decisions of the Commission, so when there is state aid, the member states need to notify that to the European Commission, and the Commission can, under certain circumstances, allow the state aid measures by member states. And that was the case in related to the chips. the semiconductors manufacturing. For example, the Commission already approved hundreds of millions, and actually today would be billions of euros of state aid, for example, here by the Italian and the French states to invest in or to provide aid to semiconductor manufacturing. Also, major companies are, for example, TSMC, which is the main Taiwanese firm manufacturing semiconductors, including some of the most advanced semiconductors, are announcing and are starting to invest billions of euros in manufacturing facilities here in Germany, but also in other parts of Europe. So that's what I wanted to say about the CHIPS Act. And now let me just discuss a bit more. Obviously, it's an area in which clearly impacts the Indo-Pacific countries. We've seen shifts, and we are witnessing shifts in supply chains in those countries, and shifts back to, for example, the EU or the US. But then, in terms of connectivity, there are also important developments. For example, research collaboration on 5G, on 6G, on connectivity network, on connectivity between the EU and Korea. In some, there's a lot of standardization initiatives, for example, between the EU and Japan to facilitate standardization between for manufacturing of specific digital products. And with India, there's also and the ASEAN countries, partnerships and shared strategies related to connectivity to facilitate. So with the EU, for example, look, I think I have a map here. There are projects of development projects between the EU and the Association of Southeast Asian nations, the ASEAN, to facilitate investments in connectivity in those in a lot of those countries, as you can see here, with some specific initiatives. And with India, there's a similar connectivity partnership where the EU is also investing in specific infrastructures in India. So this is it for it was rather short, but I think I just wanted to cover some of those important issues because especially the European CHIPS Act really impacts countries in the Indo-Pacific region because of those investments that are being made in the EU to relocate the production of semiconductors in this region, and to avoid to kind of guarantee the sovereignty of the EU in terms of critical infrastructures. And so I thought it was a general, also along with the EU's digital strategy, a necessary step before we go in a bit deeper into some of the legalities of the European data strategy and the regulation of online platforms and of artificial intelligence. But I'm very happy to answer your questions if you have any questions now related to the European CHIPS Act or the EU's data strategy, digital strategy. So don't hesitate if you have any questions. Not sure.
I have a question.
Yes.
Like we are seeing a lot of like there's been a lot of shoring of, these chip advancement that we're seeing today. It's been shored in the Silicon Valley of the US or in China. So there are these two extremes, especially in the semiconductor space, and then you have Taiwan as well. So they have like these unaccounted boardrooms in the Silicon Valley, which takes a lot of decisions. And then you have party heads of state in China who set the tone on how they're going to interact with the rest of the world when it comes to very critical technologies like semiconductors. How will middle powers, like right now in this situation, the European Union is not at an advantage, right? So how will you navigate this extreme of the US and China? Because they are, in a way, they're setting the tone, right? So
yeah, definitely. The in the end, let me just maybe go back to this graph. Indeed, and you can see as you well said, like when you look at just the sheer the sheer volume of investments in the US and in China or in South Korea, it's nothing compared to the investments of Europe. So Europe is kind of a middle actor in this space. What is happening also is that the companies that are investing in that are actually manufacturing those semiconductors are usually not European companies. They are US companies, or they are Taiwanese companies, or South Korean or Japanese companies, and they come themselves to invest in Europe. No, so the European companies are strong in manufacturing equipments. So those equipments are still a key, and I think that's where the EU is actually a major actor and still keeps relevance in this space. It's with key companies like ASML, which manufacture the equipment. So without them, some of the most advanced semiconductors would not be able to be manufactured yet. Would not be able to be manufactured, and that's where I think the EU still has a leverage in terms of in this space. Otherwise, as you said, for the investments and when you think about it, the subsidies and the private investments being made in Europe for the production of semiconductors in Europe are subsidizing basically US companies and Taiwanese companies coming here. No, so it's the EU clearly doesn't have the strongest hand in my opinion, but still has the means actually to attract investments and to the most important thing here is I think to just to realize that it's just made to ensure the sovereignty of the EU in terms of these critical infrastructures, and that the EU is trying to be a relevant actor still in this space. But let's see how it develops, because it's mainly a strategy for now, and there are already important investments. But given the investments of the other jurisdictions, let's see how it plays out within the next 5 years. No.
Yeah, thank you.
Thanks. I don't know if anyone else has an other question. Again, it was we didn't go too much into very legal aspects of this of these because I mean most of what I wanted to say about the EU's digital strategy and and the investment in digital infrastructures was mostly policy oriented. Tomorrow we will be more go more into the details of the legal obligations and the rights that were adopted for the regulation of online platforms and AI systems. I don't know how you want to proceed. I don't know, Professor de Sadeleer, if you're here, and how you want to proceed.
So,
Or yeah.
Professor de Sadeleer is not giving a lecture. Are you going to close for today?
What-
What have we been reaching? We are still the Digital Market Act, the digital.
Yeah.
Yeah, no, yeah, but that's I thought we would do it tomorrow, no?
Yes, it's there because continuously.
Yeah, I think then we stop at this stage.
Okay, yeah.
Yeah, I think it's better than we stop here. There has been we will discuss the ways in which we shall deal tomorrow, because I have also to